Okay.
Right. Can I just check, is the court ready? Okay, thank you. I'll bang the door, you can say court rise and then.
Yeah.
Do you know what you do?
Yes, I'll do it for the
Oh, okay.
14 seconds.
Oh, okay.
Don't go for something.
Okay.
Yeah.
Right.
Court rise. Appeal in the case of International SARL versus Grain House International, formerly known as Compagnie.
Yes, Mr. Loxton.
May it please you, my lords, in this matter I appear on behalf of both appellants, my learned friend Mr. George Hilton, and the respondent is represented by Mr. Lawrence Acker of King's Counsel and Mr. Patrick Dunn-Walsh.
Thank you.
Lords, before I kick off, may I mention a couple of housekeeping matters?
Yes.
There are, as the court will know, a very large number of reported cases to do with contempt, both from the commercial court and from this court. We have striven to keep the citation of authority in this appeal to an absolute minimum, and to that end we produced a schedule of propositions that were not contentious, and juxtaposed with that schedule a very brief citation from what will be in most cases very familiar authorities from which the proposition derives. Lord, secondly...
May I just say that was a very helpful approach.
Well, my Lord, thank you. My Lord, secondly, and in the same vein, and at the request of the court, we've prepared an agreed note. It doesn't bear any signatures, but it is in fact agreed, dealing with statutory instruments.
Yes.
By which orders for sequestration against companies may be enforced against directors. That's a freestanding document. My copy came to me pinned to the front of what we call the Authorities 2
Yes.
bundle, which contains authorities which the court expressed an interest in looking at.
Yes, again, that's been very helpful.
Well, my Lords, may I say, in relation to both those materials, that a tribute is due to my learned friends Mr. Acker and Mr. Dunn-Walsh for the friendly cooperation that they've shown in getting those materials together. My Lords,
Can I just say I've got the note about the changes to the various civil procedure rules. I'm not sure I've seen the first of the two documents.
I'm sorry, my Lord, I should have mentioned, it is tab 1 in the authorities bundle.
Right, thank you.
I should have mentioned that.
Got you. Yeah.
And I will make, the propositions are uncontroversial, but I will make very brief reference perhaps to those.
Thank you.
My Lords, these are appeals by GHI, the first appellant, against 4 separate contempts of court found by Mrs. Justice Cockerill, as you will have seen in her judgment handed down in the 26th of January of this year. Mr. Boutguery, the second appellant, appeals against a single finding of contempt, in his case, that with knowledge of the relevant court orders, although not a party to them, he either aided and abetted, the words used by the respondents, the breaches by the first appellants, or willfully failed, the other words they use, to take reasonable steps to secure compliance. And both appellants appeal against all those findings, and also against the sentences imposed, which in the case of the first appellant was a fine of £75,000, and in the case of Mr. Boutguery, the second appellant, an immediate custodial sentence of 12 months in prison. We propose to deal, I hope briefly, seriatim, with the various contempts found against the appellants. But before I do that, I would like to make a general point about the evidence in the case, in the background, which affects, in our submission, every aspect of these appeals, both against conviction and against sentence. My lords will have noted from the skeletons that there is a quite startling discrepancy or contrast between the evidence from GHI as to the extent of its assets according to its audited accounts for each of the years from 2019 until 2022, as evidenced by an affidavit from Mr. Boutguery, which was produced at the sentencing hearing. It wasn't before Mrs. Justice Cockerill at the liability hearing, which preceded the sentencing hearing by, I think, about a week. That material indicated that over the period in question, GHI has, according to its audited balance sheets, maintained assets of the order of $250 million US dollars, 250 million US dollars, which of course contrasts both with the evidence which was initially produced by GHI in response to the asset disclosure order made back in 2019, when they said that in response to the order, that their assets consisted of bank accounts with negative balances and a number of properties, which, at least according to ADM, the respondents, and indeed to Mrs. Justice Cockerill, were so encumbered with mortgages and charges that they had effectively negligible value. So you've got zero looking at something in excess of 250 million US dollars. I just make these swift points.
Sorry, just before you do so, two things about that. First of all, I think we've got Mr. Boutguery's sixth affidavit, one numbers them sequentially, which is, I think is the one you're talking about.
Yes.
We haven't got any of the material said to be attached to it,
No.
which is what you're currently, as I understand it, referring to for,
Yes.
for the submission as to value.
Yes.
And secondly, if I can give you both points and you can deal with both of them, should we be looking at it at all, since it postdates the hearing and the findings on contempt?
Well, that's a point. The second point is one that's made by ADM. Of course, even if it were not, as a matter of fact, relevant to the findings on liability, it's, in our submission, certainly relevant to sentencing. That's why the document was produced. The exhibits to that affidavit are extremely voluminous. There are hundreds of pages, and in an effort to keep the supplementary bundle within reasonable bounds, we made a decision to omit that material. What we rely on for the very broad purposes of the submission and the points I'm just about to make is what is said in the body of the affidavit about the existence of that material. He refers to the balance sheets, he refers to the amounts, he refers to the auditor's certificates. In our submission, it doesn't, for today's purposes, carry the matter much further to actually look at the material. So,
but your submission that it's relevant to sentencing is, well, I think at least it was before the judge, not to show that there were vast assets available because the material was incomplete, it was too late for anybody to digest it, and so on, but to suggest that here was an albeit belated but genuine attempt to comply with the order, and either there should be an adjournment to allow further time for that to be digested, or if not, at least it showed already a different attitude which was relevant to sentencing. But none of that involves relying on the asserted factual basis that there are in fact assets worth vastly more than the extent of the arbitration award with interests and costs.
well, the Lord has, if I may say so, very fairly summarised the main points that were being made around that material at the sentencing hearing. But I'm not, I think, conceding that that was the only way in which that material was relevant. There was a lot of it. It arrived at the last minute. It was in stark contrast to the picture painted by the arguments of ADM, but not, I may say, in stark contrast to ADM's own evidence, because they kicked off this piece back in 2019 with affidavit evidence from Miss Pritchard in support of the application initially for a asset disclosure order and subsequently for a freezing order, in which they produced the accounts for, I think, year ended 2017, which were then the latest, which showed a very similar picture. One of the points we wanted to make, my Lord Justice Popplewell, before he intervened, was that it is, since ADM themselves had consulted this material, it is really inconceivable that they didn't subsequently, as each year went by, revisit the same source, the publicly available account, the first place you'd look. And they must have known throughout this piece that the picture originally painted by them on affidavit, Miss Pritchard's first affidavit, produced in front of Mr. Justice Waxman, that picture hadn't really changed. The balance sheet, there wasn't a sudden financial collapse or anything of that sort. If there had been, no doubt that fact would have become apparent. I don't want to make too much of this. I simply introduce it by way of background, but may I just make swift points? Firstly, that the extent of GHI's assets, according to its balance sheet, are a matter of public record in Morocco. Secondly, ADM have always had access to those records, and indeed, as I have said, relied on them to obtain the original asset disclosure and freezing orders. And I give you the reference without taking you to it. That's the first affidavit of Katie Pritchard, dated 16th of January 2019, which is in the supplementary bundle at tab 9, and it's paragraph 26 at page 40. Thirdly, GHI have always known that ADM were aware of the prima facie extent of their assets, not least because they were referred to in the initial application for the asset disclosure orders and freezing orders. And fourthly, failure to disclose the assets as shown on those balance sheets is, on the face of it at least, a contempt of court. There are explanations which are not relevant to this appeal as to why GHI construed the court's orders as only requiring them to disclose bank accounts and real property assets. But the important point for you is, and was for Mrs. Justice Cockerill, that that's not the contempt that was charged against these appellants. And that raises in our submission, and it's my fifth point, the unanswered question as to why ADM have not pursued GHI and Mr. Boutguery for details of its assets, of its enormous assets, as disclosed by those accounts, and if necessary, use the contempt jurisdiction to give teeth to that inquiry. And my lords, we would suggest that the answer to that question is plain to see, that for some reason ADM made a tactical decision faced with difficulties in enforcing the GAFTA Award in Morocco, difficulties apparently associated with the Moroccan court's reluctance to accept that the GAFTA Award should be enforceable in their jurisdiction, and thought it better to go by a different route, to take the limited disclosure given by the appellants and to adopt the fiction that because that's what they'd said, that must be the true extent of their assets, and therefore they had not maintained $4 million worth of assets in Morocco, and therefore couldn't trade, and that it would be a more efficacious method of extracting a payment from the appellants to accuse them of contempt of court in relation to the limited disclosure they had made, rather than to say that there was a massive non-disclosure of all the assets described in balance sheets. And that, we say, is the fact, whether or not the evidence from the appellants about this was before Mrs. Justice Cockerill at the time of the liability hearing. It is a fact that those assets were evidenced in the way that I've said, and that ADM knew it. And that is something which in our submissions is helpful to keep in mind when you look at the particular contempts which have in fact been pursued. Not saying, look at this £250 million worth of assets, where are they, give us the details, but rather you've made this limited disclosure, we can pick holes in it here, here and there, and base a contempt case on that. So, my lords, against that background, can I turn to the first of the contempts alleged against GHI, which relates to a further, not the original disclosure order, but a further disclosure order made by Mrs. Justice Cockerill in early July of 2021. It's not clear to me whether that was on the 2nd of July or on the 6th, but it was early July of 2021. And we needn't look at it, but that is in the supplementary bundle under tab 8, at pages 33 to 34. And what GHI were ordered to do was to supply details of the credit facilities that they had with their various banks. I think they had 7 banks. And they had disclosed the existence of those banks and of accounts, but by way of a further disclosure order, they were ordered to disclose what credit facilities were available with those banks. And also, and importantly, bank statements going all the way back to 2019, monthly bank statements for the 7 different banks. No application that for further disclosure related to the published balance sheets of GHI, but picking up on the disclosure of the bank statement, of the bank accounts that had been made, and asking for those particulars. That order, which was quite an onerous one, covering quite a long period with 7 different banks, I think a total of 168 bank statements were encompassed by the order was complied with fairly promptly by GHI with 483 pages of material, the vast majority of which were the various bank statements rather than the credit arrangements, which in the case of each bank were just typically a couple of pages each. Some of that information was redacted as GHI were subsequently to attest by affidavit in order to protect commercial sensitivity. Fairly modest redactions, typically of the identity of guarantors of the various arrangements. I think
we don't have, I think, either in redacted or unredacted form in our bundles the credit facilities, do we?
My Lord,
Well, speaking for myself, I don't find that terribly helpful, since one of your grounds of appeal is that the judge erroneously characterised the extent of the redactions.
yes. Well, my Lord, that's right.
I mean, you've submitted that these were relatively modest redactions. The judge found otherwise, which we to take.
Well, my Lord, it may not be the quantity, but perhaps the quality that was in issue. Yes. Mrs. Justice Cockerill said that virtually all material information was withheld.
Yes.
But I have told you that the bank statements, which one might have thought was the most material disclosure because it showed whether or not GHI had been trading, and if so, on what scale and with who, were not redacted at all. I'm not in a position to tell you what the rationale for Mrs. Justice Cockerill order about credit arrangements was. I know it's an order which is quite frequently made, but for different reasons. Why in this case she thought it was very material, for example, to have the identity of the guarantors, I don't know. I'm not.
I haven't seen the credit facilities, so I'm in the dark, but it may be that she had in mind Ablyazov number 10. Where
Sorry, my Lord.
It may be that she had in mind Ablyazov number 10,
Yes.
In which it was held that credit facilities where there is a power to direct that the lending goes to a third party
Is an asset.
are assets.
Yes.
And given the rather surprising disclosure in Mr. Boutguery's earlier affidavits that the balance on the various accounts had remained the same at March 2019 and at the date on which those affidavits were sworn 2 years later, that might have given cause for some suspicion that the facilities were being used to enable trading by being available to be diverted to third parties. So I can't say what was in her mind, but speaking for myself, I don't regard it as self-evident that by producing the bank accounts and not the terms of the credit facilities,
Well, they did produce
well, initially
redacted form.
in unredacted form, that would necessarily have provided all the information that the judge thought would be intended to achieve the purpose of the order.
Well, my Lord, we started this exchange by considering what it was that Mrs. Justice Cockerill thought was important. My Lord has supplied an answer, but Lord, I don't know.
Well, what I'm really saying is, in order to evaluate your submission, that really what was disclosed in the form of the bank statements and the redacted credit facilities was all that really sensibly needed to be known, I would myself like to evaluate that by reference to the redactions and the unredacted versions of the credit facilities.
Lord, with great respect, I am sympathetic to that predicament, but my lords will have in mind that repeated helpful advice from the Court of Appeal at different times, keeping documents to a minimum. Our supplementary bundle, which is entirely net of exhibits, is very substantial, probably more substantial than you would typically like.
Yes, well, I'm not for a moment casting any doubt on that as a very commendable objective. But if, as you say, the credit facilities were only a couple of pages each, and there are 7 or possibly 8 of them, then it oughtn't have been to be too onerous
Well,
to provide.
I accept that, but perhaps more important, that as you would expect, rather than launching a contempt application in respect of these redactions, what very sensibly GHI solicitors did was to send a letter saying, can you give us the unredacted versions, which is a course which in various cases has been commended as the first line of attack in this situation. Well, that's what they did, and my clients responded without argument or demur. They supplied the unredacted versions, and unhappily they omitted one, which was inadvertent. There was no reason for doing it. They simply overlooked it, and that was the arrangements with Société Générale.
I thought the explanation was that they didn't have it, not that they overlooked it. Have I got that wrong?
Might be Banque Populaire, the bank statements. My lord may be right, but it was a very small matter which was in the event rectified, and whether it was lost and found or whether the inadvertent omission was corrected, I'm not just at the moment in a position to say, but the main point is that well before this contempt application came on for hearing, that had been put right.
But after it had been issued.
Yes, in that case, yes.
The judge was well aware of all of this.
My lord, yes. Although in our submission, she in the event analysed the effect of it incorrectly, which is what I'm going to come on to.
Yes. It's really her conclusion at paragraph 57 that you need to challenge before this court. Is that right?
My lord, what I'm looking at is her conclusion at paragraph 85 of her judgment that this was technical, historic, and had been purged, and it was for those reasons that she saw fit to impose no...
Yes, that's paragraph 57, page 85.
Yeah, I'm sorry, my lord, my note took me to the page,
Yes.
not the paragraph.
No. What you'll have to persuade us of is that this court, sitting on appeal, not at first instance, is entitled to interfere with her conclusions.
Yes, well, my lord, that's precisely what I want to address.
Yes.
In our submission, the judge was correct in describing the breaches as technical in the sense identified in the sector guard case and other subsequent cases. In other words, that it was shown that GHI had knowledge of the order and of the facts constituting the breach. That's to say, the redactions. They obviously knew that there were redactions because they carried them out, but not that the breach was that they knew that by redacting the credit agreements, that would constitute a breach of the agreement. And my lord, that was in our submission a correct finding. These were Moroccans who didn't speak English, whose affidavit evidence showed that they didn't understand very well the English legal procedure, and it might be thought that to redact, to protect commercial confidentiality was could be done by someone in completely good faith and with no intention at all of being contemptuous in relation to a court order. But be that as it may, our second submission is that in finding the breach was technical only, and or, I would add, she might have found was so trivial as to come under the de minimis rule, she should have come to the conclusion, not that there was a contempt which need not be marked by any penalty, but that there had been no contempt at all. And my Lord, I get that support for that submission from the Sector Guard case, which is in your authorities bundle under tab 5. If I could invite you just to look at it for a moment, at page 74, tab 5. Yes, this is Mr. Justice Briggs's case.
Yes.
And if I can take you to paragraph 47.
Yes, thank you.
It's a very well known passage.
Yes.
Committal proceedings are an appropriate way, albeit as a last resort, etc. Appropriate means of bringing to the court's attention serious, rather than technical, still less involuntary breaches. In my judgment, the court should, in the exercise of case management powers, be astute to detect cases in which contempt proceedings are not being pursued for those legitimate ends. Indications that contempt proceedings are not being so pursued include applications relating to purely technical contempt, which is what Mrs. Justice Cockerill correctly found was the case here, and applications not directed to obtaining compliance with the order in question. That also applies, although the learned judge didn't identify that. But she did identify that the contempt had been purged, and so there was simply no point in pursuing it in a contempt application before the court. And so my submission is very simple. If you are sympathetic to the general idea that contempt proceedings, there are far too many contempt applications are being made currently, and something needs to be done to discourage allegations based on trivial contempts, which are not aimed at getting compliance with an order because they've already been complied with. You ought to say so. It's not just that this was a technical purge contempt, and so therefore shouldn't be separately punished. It wasn't a contempt. It wasn't a contempt.
Isn't the point that this Justice Briggs was making was that if at some point in the early stages of a contempt application it can be seen that what is being alleged is, even if true, the merest technicality, i.e. breach, then the court would strike it out and say it's an abusive process to pursue it. But Mrs. Justice Cockerill had heard the contempt application and had found it proven. So why does Mr. Justice Briggs's comments have anything to do with it?
And Julia's going to suggest a response. Well, my lords, this was a contempt which the judge found was technical. That's to say, she could not find and would not find, albeit perhaps the issue was finely balanced, that had been done deliberately and it had been purged. And in relation to all the matters alleged under Contempt 1, these matters had been sorted out well before the contempt application came on. And so, my lords, it's not a case of compliance in the face of an imminent contempt proceedings. It's, in our submission, evidence of someone who's done what was asked of them, which in this case was to supply unredacted documents, pretty well as soon as they were asked for.
But I mean, again, I understand that, but Mr. Justice Briggs's comments in paragraph 47 are directed at a different point, I think, which I have to say I've done myself in the past, which is to put an end to contempt proceedings at an early stage, where you can see that they will serve no proper purpose. They're being pursued for inappropriate reasons, and people often do, as a distraction from the resolution of the main dispute. But that's a very different time for the court, as Mr. Justice Briggs says, to exercise its case management powers,
Yes.
i.e. to put an end to contempt proceedings at an early stage.
Yes. But
Whereas
I do appreciate.
Mrs. Justice Cockerill was at a completely different stage. She'd heard it. She said there was a breach.
Yes.
Therefore, it's a technical contempt or contempt, and that why isn't that appropriately then reflected in
Well, my Lord,
sanction?
As it happened, this technical objection to compliance by GHI wasn't before the court until the contempt application was heard. There wasn't an opportunity to. I do appreciate the point that Mr. Justice Briggs is talking about case management, whereas Mrs. Justice Cockerill was talking about what to do. But if a technical contempt, the pursuit of a technical contempt, has arrived at court, it's not too late then to say this shouldn't have been pursued.
Well, did you apply to strike it out at any stage?
Well, my Lord, that it was Mr. Hilton was appearing then.
So I don't mean you. I mean
Yes, yes.
collectively.
Yes, he said this is an abusive process. It's not a contempt at all, and that argument was rejected. And my Lord, it's worth a decision in our submission from this court. I mean, either it's all right to do this, and the court deals with it by way of saying, yes, it is a contempt, but we're not going to impose a separate penalty.
If what you're suggesting is that what Mr. Justice Briggs referred to as a case management power ought to have been exercised, then haven't you got to show that Mrs. Justice Cockerill acted in a way that no reasonable judge in the exercise of their case management powers could have acted?
No, I'm not suggesting this was a case management decision by the time it reached Mrs. Justice Cockerill. I'm saying the fact that it had not been bowled out at an earlier stage, there's no reason why she shouldn't say this is not a contempt. It would have been better to have struck it out at an earlier stage, no doubt.
But it was a contempt. There are two separate questions. One is whether something is a contempt, and the second is whether it is of such a trivial nature or has been purged that it would be an abuse to allow it to be pursued as a matter of case management. She was being asked to say it wasn't a contempt. She held that it was.
Yeah, well, we're saying that that's wrong.
You're saying that's wrong because it was trivial, or because it was purged?
Because it was trivial and because it was technical, and there was no intent to breach an order.
But that's not an ingredient of a civil contempt.
Well, Lord Sir,
Is it?
the courts have been astute, it seems, to draw a distinction between serious contempts which are worthy of punishment, which it is in order to pursue, and contempts which are purely technical, which it is not.
Well, that, as it seems to me, may be a function of the abuse jurisdiction, not the existence or non-existence of a contempt. Here we had a case where, in the relevant respects, at the date that the committal application was made, there was clear non-compliance. There was subsequent compliance, and then a question might then arise: well, although there's been a contempt, clearly been a contempt, would it be an abuse to pursue that to a hearing where, if it was not deliberate, it amounts to a contempt, but it wouldn't be worthy of punishment? And as I understand it, your submission is, or at least has to be, that by the time one got to the hearing before Mrs. Justice Cockerill, it was an abuse to pursue an allegation of contempt, which, although it had taken place at the time when the application was issued, it had subsequently been purged or remedied. Is that we've said pretty promptly? The answer is not I think, until 2 days before the hearing the first hearing in May 2022. As I understand it, the further disclosure order ordered the credit facilities. They were provided in redacted form in August. They were pursued in correspondence in September and again in November,
Yes.
some but not all were provided in unredacted form. When the committal application was issued early in 2022, the SocGen facility had not been provided. I think on the eve of what was going to be the hearing in May 2022, although it was then adjourned because there wasn't time, then finally the unredacted form came forward. If I've understood the chronology,
I think so, my lord. Yes.
that's what it is. So when you say provided pretty promptly,
You say
I'm afraid that's not how I would characterise
well, my lord,
that provision.
all, you say some but not all. All but one were supplied fairly promptly. One was not.
Right.
And my lord, that in our submission, and we're not talking about a failure to produce a document, but simply to correct the error of a redaction inappropriate in Mrs. Justice Cockerill's view. And in our submission, the court is entitled to take a robust approach to that, not to say this is a trivial contempt, or this is a purge contempt, or this is a technical contempt. Yes. Simply to say it's not a contempt at all. It does not have the character of a contempt. And my Lord Justice Popplewell proposition is founded on, seems to be founded on a premise which one hears quite frequently, that every failure to abide strictly by the terms of a court order is a contempt. And it may not be a serious contempt, it may be a trivial contempt, it may be a technical contempt, but it is a contempt. But we would say no. If it's inadvertent, if it is not done, if it's done by mistake, if it's not done with an intent to flout a court order, and indeed if there is a breach, but the order is not clear, and you could say here that the order didn't forbid redaction, and for someone to assume that they were entitled to redact was a misreading of the order rather than anything that could be described as contempt. But there are a whole host of circumstances in which one can say it's not any breach which constitutes, or ipso facto constitutes a contempt. And so we are inviting a slightly more robust approach to what type of contempts it is appropriate to pursue and what not. And if it is not appropriate to pursue a contempt, the easiest way to characterise that is to say this is not a contempt, rather than say it's not a very serious contempt. But Lords, may I?
Well, I think we understand your submission on that. I am conscious that there's quite a lot of grounds that we're going to need to go through.
Yes.
And of course, the respondents are going to need time.
Yeah, absolutely.
I'm not criticising you at all, Mr. Moxon-Brown, but I think we understand your submission on contempt one.
Well, my lord, it really extends to contempt two.
Right.
What I've said is really the same. It's really the same points. For good or ill, either I'm right or I'm not. But it's not really a very different situation.
Right.
Contempt 2 relates also to a failure to disclose periodic statements of account showing transactions. I just emphasise the words showing transactions affecting each of the facilities of which disclosure had been made. Well, so far as that is concerned, I just to give you the scale of it, there were 2 years, which is 24 monthly periods to disclose, and there were 7 accounts. So 7 times 24 is 168. So 168 bank statements were being looked for, and all but 4 of those were disclosed in unredacted form. So what we're looking at is a failure to disclose 4 out of 168 bank statements. They fall into 2 categories. There's the Arab bank statements for April and May of 2021, which it is said was an oversight, subsequently rectified. And secondly, 2 statements from Bank Popplewell, which were not disclosed according to the appellant's evidence because there were no transactions during that period, and they said both that they thought that didn't require, since there were no transactions, it didn't require any disclosure, and secondly, that they hadn't in any event got those statements because it wasn't the bank's practice to issue statements with showing nil returns. An explanation which Mrs. Justice Cockerill was perhaps understandably pretty sceptical about, but it transpired when those bank accounts were disclosed that there were no transactions in the relevant period, and so it really wasn't a great matter in the grand scheme of things. The arguments below were that there was no obligation to disclose the Banque Populaire statements because they showed no transactions, whereas the order was quite clearly to provide statements of accounts showing transactions. That was rejected. Our submission is that threefold. First, that the Arab Bank breach was inadvertent and it didn't even reach the threshold of being technical. And it was rectified as soon as the mistake was pointed out. And therefore the pursuit of it in contempt proceedings was completely unnecessary. Secondly, so far as the Banque Populaire statements are concerned, that was a trivial breach, if indeed it was a breach at all, and its pursuit served no purpose. And thirdly, that for the reasons that I was advancing in relation to the first contempt, that rather than finding that this was not a serious contempt, it was a technical contempt, the learned judge should have found it wasn't a contempt at all.
Right, thank you very much.
Well, if I can move to contempts 3 and 4, which the learned judge described as the centre of gravity of the contempts alleged, and
yes.
these were the contempts that attracted, in Mr. Boutguery's case, a prison sentence.
Yes.
Lord,
Are you going to take them separately or jointly?
separately, but there was obviously an overlap.
All right, thank you very much.
If we can look first at the particulars that are alleged, which are in your core bundle under tab 8 at page 108. And it's number 3, contempt 3, in breach of paragraph 1C of the asset disclosure order, that's the order of Mr. Justice Waxman, the first defendant failed to disclose the following encumbrances on the following properties. So the contempt alleged is a failure to disclose encumbrances, not to misstate the value or to omit to identify the relevant properties, but specifically failing to disclose encumbrances. If we can then look at Mr. Justice Waxman's order, which is in the supplementary bundle under tab 2, page 6. You'll see the first part of the order under letter C, all other assets, I stress the word assets, located in Morocco exceeding $75,000 in value, whether in its own name or not, and whether solely or jointly owned, giving the value, location and details. And so you observe immediately that there's nothing here said about encumbrances in terms. What is asked for is the value, and what the issue in our submission is really twofold. One is what value means. Does it mean the value of the property, what the order seems to be talking about, or does it mean the value of the defendant's equitable or beneficial interest in the property? And secondly, if the property is in fact encumbered, and to the extent that it's encumbered, whether in fact it is an asset at all. In other words, whether it's caught by this order. Lords, my first submission is that the order which I've just shown you is ambiguous as to whether it refers to value of property or the value of the defendant's interest in property, and in support of that I say that the order doesn't refer to providing details of encumbrances or indeed to identify third-party interests. It simply says you've got to give the value irrespective of whether there are third-party interests or not. So if in ordinary language you are asked the question, what is the value of your flat and what's its location and what are the details, you could ordinary person very sensibly argue, including if they were an English speaker, including perhaps if they were a lawyer, might say, I've got a flat, it's worth 200,000, it's in Fetter Lane, it's got 2 bedrooms and the usual offices, and it's in a purpose-built block. And that, in our submission, would be a very natural way of answering that question. Someone says, what's the value of your property? No ordinary person would not suppose that what was being asked is, what's the value of your property after the mortgage has been paid? Simply, what is the market value? That's what, if you want to know about encumbrances, which very often is required by a claimant, then you say so in the order. In our submission, ADM's proper complaint here was that the figure given was wrong. If they're right that the correct way of construing this order, after consideration of the pros and cons of the various constructions, if it's right that what one's really talking about is the value of the beneficial interest, then the proper criticism of GHI here would be that the value they gave was wrong, because it was the value of the property, not the value of the interest. But not what's been alleged, which was a failure to spell out.
Well, aren't they two sides of the same coin? Because as I understand the argument against you, it is that you were not giving the true value because value meant your value of your interest, and therefore that could only be comprehensible if you explained the details of the encumbrances.
Well, Lord, I think the point I'm making is that if the proper construction is as found by Mrs. Justice Cockerill, then there are 2 different ways in which you could deal with it. You could say the property is worth 200,000, but there's a 100,000 mortgage, or you could say the value is 100,000.
Yes.
But you don't have to. An answer, it's worth, my interest is worth 100,000, would be a complete, would in our submission be a complete answer. They can go and, the judgment creditor can go and look at the land registry if he wants to see whether it's worth enforcing or how he might set about enforcing. But these are not particulars that we're being asked for.
I mean, the words that are used in each of the 3 sections are whether jointly or solely owned. I think, as I understand it, you say, amongst other things, that indicates that what is required by way of value is the gross value. Because, for example, if you have a jointly owned property, I mean, let's say husband and wife own the property and this form of order is made, it's the use of the expression whether solely or jointly owned would be irrelevant if all you were actually asking for was the husband's interest in it.
Yes. Yes.
I mean, because it would just be, in a sense, his assets. Therefore, the question of whether it was solely or jointly owned would be irrelevant.
Yes. Well, it's ambiguous.
Well, yeah. I mean, this form of wording is sort of has some similarity to words that are often used in a disclosure order in a freezing injunction, but they're divorced from that context here.
Yeah.
So as I understand it, what you're saying is, no, it's value, meaning gross value of the asset.
quite regardless of
whether somebody else owns it jointly with you and therefore, in a sense, would be said to have a 50% interest in it.
Yeah.
Whether there's some other encumbrance over it, which we might reduce the...
That's how my clients construed it.
Yeah.
And Mrs. Justice Cockerill erred in our submission by...
Where do they say that that's how they construed it?
In her judgment.
No, where do your clients say in their evidence that's how they understood it at the various times?
Well, I'm not sure that they did.
No.
But it's pretty plain that there was a misunderstanding, because otherwise it wouldn't have been necessary to give any disclosure at all. Because
why did they start disclosing encumbrances?
Well, because they were asked to.
Is that right? Where's the request for details of encumbrances that came before the, I think it's either the second or the second affidavit, I think, in which encumbrances at first.
It was a request made, I think, by letter.
Could you find that for us, please?
Well, it's not. We haven't got any of the exhibits to Katie Pritchard's affidavits, but well, I can certainly.
Well, it may point to some importance, because if there's no evidence that they understood it in this way, then the point my lord's made is an important one. Your response is, well, they only gave details of encumbrances because they were asked for them.
Yes.
And that you'll need to make good on the evidence. I'm not saying it's not so, but I haven't seen that from the evidence that we've got.
I don't say that's the only reason, but I believe that they were asked for the encumbrances, and that's what prompted them to supply that information.
But it may be relevant. It may not be for the question we have to decide. What your clients understood the order to mean, and you've asserted that they understood it to mean as you say it is to be construed. But if there's no evidence of that, I'm not sure we can proceed on that basis, can we?
Well, my lords,
Can we?
the obligation under Mr. Justice Waxman's order was to disclose assets worth more than $75,000, and if the respondents are right, and if Mrs. Justice Cockerill's finding was right, that in fact these properties had no equitable value, no significant equitable value at all, then there would have been no need to make any disclosure.
That isn't what they did, and that's why the particulars complain about failure to give details of the true encumbrances. You may be right in saying that if that's what the order means, what your clients could have done is simply said none.
Yes.
But they didn't. They said these are the properties and these are the values, and therefore this is what we are disclosing. And it was the misleading nature of the disclosure on ADM's evidence, misleading, which founded the allegation that by failing to give details of the full encumbrances, it was a breach of the order.
Yes, look, we may be at cross purposes. The point I'm making is in support of my submission that plainly the appellants did misunderstand what was being asked, because otherwise, if they'd understood that it was net value, then they wouldn't have made any disclosure.
But that's, sorry, that's really the point, isn't it? I mean, as I understood your first point, you said, look at the allegation of contempt. It says, fail to disclose encumbrances. Your first point was, look at the order. It doesn't require disclosure of encumbrances. That's your first point. They're just not in breach of the order at all. So there is a question about why at some point they did start to disclose encumbrances. The second point, as I understand it, which is related, is you say this order simply requires the disclosure of the gross value of assets, whether solely or jointly owned, whether subject to encumbrances or not. It's just if there is an asset which has a gross value of more than $75,000, you have to disclose it, give its value, which would be the gross value on that interpretation, location, where it is, and then it says details of such assets. Now, question.
That's as long as a piece of string.
What does details mean? Now, I understand you say, well, either on this true interpretation, it's simply no breach not to disclose disclose encumbrances at all because it didn't ask for them. Or at very least you say it's ambiguous. And as I understand now that I've seen the agreed principles, you say if it's an ambiguous order, it's not suitable or not capable of constituting the basis for a contempt.
Yes, and I would add to that that the question of how the individual in fact understands, which I think was the nub of Lord Justice Popplewell's question, is not really material. If it's ambiguous, then
yeah.
you
So
can't have a contempt.
it fits with a previous submission I think you made, as I understand it. You say if an order is ambiguous, it's simply whatever the court might think of its true interpretation, and therefore, hence, whether if on that interpretation it was breached is irrelevant for the purposes of contempt. You never get to that question. You simply say, if it is genuinely ambiguous, that's an end of the contempt.
The Lord, with respect, puts his finger on it. I was just about to go on to say that the error that Mrs. Justice Cockerill fell into was to suppose that her job was to work out what this order actually meant, and she concluded, giving it what I would call a purposive construction. What's the point of it? She concluded it was a reference to net value, and therefore.
But this is perhaps to pick up a point my Lord Justice Popplewell was, I think, making earlier. There is a difference, I think, as I understand you to be saying, between the question of whether an order is breached, which is an entirely objective question. What does the order mean?
Yes.
And the court can ultimately determine what an order means, unless it is so vague it has no meaning at all. But it can be interpreted to have a meaning, and then the question can be answered: was it breached or wasn't it? But I think you say that when you're asking the question, was there a contempt, you actually stop that inquiry at an earlier stage if the order is genuinely capable of bearing more than one meaning.
Well, that is precisely what I am submitting. Right. And the other side of that coin is that Mrs. Justice Cockerill was wrong to suppose that once she decided what it meant, that if that on that construction it wasn't complied with, it was contempt. My Lord, there's authority in support of what I'm.
Which of the agreed principles of law are you referring to in support of that submission?
Lord, it's Red Wing.
Right. Mr. Justice Jenkins.
Yeah. Which is.
Well, I think it's actually also R.L.G.D. and Smith.
Yes.
Which one is that?
The authority that Mrs. Justice Cockerill was referred to as Red Wing, although it's, if I may say so, with all respect to the judge who decided it, slightly obscure first instance case, it is frequently cited in support of the contention that which is uncontroversial.
It's put in slightly different terms in the decision of this court in the Hadkinson case, which I think is often used as the, which we have got in our bundles.
Yes, I was going to come
I'm sorry to labour this. Speaking for myself, I need to take this a bit more slowly, because I thought it was being submitted that there's an agreed principle of law, so we don't really need to look at underlying authorities. And at that stage, your answer was, look at Red Wing.
Yeah.
That's the authority. All right. Well, that I understand. And I'm just looking at that. See, speaking for myself, as a matter of principle, I'm not sure I would necessarily accept that. So if that is authoritative, then we need to explore this in a bit more detail. The reason I wouldn't necessarily accept it is that in lots of legal contexts, a court is faced with an ambiguous document. A statute can be ambiguous, a contract can be ambiguous. But at the end of the day, it has one true meaning.
Lord, I completely accept that, and that's where I say Mrs. Justice Cockerill fell into error. It is a very familiar exercise by a court, including in the context of freezing orders and disclosures orders, what actually is the extent of your obligations. and that can be something that's litigated about,
Right.
and a decision can be made, and you argue about it, and it's ambiguous, but a decision is made. But contempt is different. As my lord was saying a moment ago, if the order is ambiguous, and this is Red Wing, then the inquiry stops.
Fine, but Red Wing, with all due respect to Mr. Justice Jenkins, is a first instance authority, right? Has that been endorsed at an appellate level?
Lord, we'll give you later a precise answer to that. But
Can I take you to Hadkinson? Because I think that's probably,
Which tab is it?
which is this court. It's tab 3,
Yeah, thank you.
and it's at page 30 in the sideline passage in the judgment of Lord Justice Mummery, with which I think Lord Justice Pill agreed. Lord Justice Nurse didn't in terms because he didn't think there was any ambiguity in the order. Even if Mr. Hadkinson had committed breaches of the freezing order, was it correct in all circumstances to treat him as in contempt? Question of mixed facts of law. The basic principle of civil law contempt, though there's an obligation to comply strictly with the terms in order, the court will only punish a person for contempt of court upon adequate proof that the terms of the order are clear and unambiguous and that he's broken those terms. Now, it's not entirely clear, but if one focuses on the word punish, that seems to me to be in accordance with what I would regard as principle, because you can be in contempt, in civil contempt, without having any intention to breach an order. But if you have an ambiguous order, and in fact it means X, then if it's ambiguous and the person thought it meant Y, and that was a reasonable view to take, well, you're not going to punish him for it. But you do start where you criticise the judge, in this case for starting, by deciding what the order meant, and the ingredients of contempt don't, as a matter of civil contempt, don't as a matter of mens rea, require you to know or intend that the act you intentionally undertake is a breach. And if it means X, and you've done X, you are in contempt. But if it's ambiguous as to whether it means X or Y, although the court decides it means X, then you may not be punished for it if it's ambiguous. And that's where, as it seems to me, as a matter of principle, there may come into play the question of what the party thought it meant. If it might mean X or Y, and the court decides it means X, but a party, because it was ambiguous, thought it meant Y, well, then you may say he shouldn't be punished for it. If, on the other hand, it means X, and he thought it meant X, and he didn't comply with it, then it's difficult to see as a matter of principle why he shouldn't be punished for it, simply because it was arguable, but in fact wrong, that it meant something that he didn't think it meant.
Well, may I, with respect, take you to the next page
Yes.
of Hutchinson, on page 31, where the Lord Justice Mummery is considering the judgment of the Supreme Court of Western Australia in a case called R&I Bank of Western Australia against Anchorage.
Yes, very well known passage, yes.
Bottom of that section, before we get to D, the bank's submissions, Ip J, who was one of the judges in that case, agreed that there were two reasonably possible constructions of the word assets in the court order. He added that contempt of court is not established, not a question of how serious or punishment, but contempt of court is not established if on the proper construction of an ambiguous court order it is revealed that the order has been breached by the conduct of the defendant. So you can find out what the order means, and you can discern.
That's consistent, if I may say so, with what I was putting to you a moment ago, which is that a document may be ambiguous, but at the end of the day, it has one true meaning, which the court gives it.
For sure.
And then you ask, but that's different from saying, well, it's ambiguous, so we'll just shrug our shoulders, we won't do what we normally do as a court and give it its true meaning, and because it's ambiguous, there can be no contempt. Well, I thought that was the principle you were...
Well, my lord, it was, and I...
Can I, sorry, just at the risk of, to pick up my lord's point, it's a point I made earlier, I thought it was accepted because I looked at, in fact, page 4 of the agreed series of propositions, on page 4 of this bundle, where from a passage in knowledge is cited with a number of references to it, but the respondent accepts the principle that an order must not be ambiguous to found a contempt.
Yes.
Now, so I understood that what you were submitting is that, yes, it could be a breach because the court, as my lord has just said, can always determine what a document means and can say, is that what was required or isn't it? Was it breached or wasn't it? That the court can always do, and will have to do if, for example, it becomes important to ensure that proper disclosure is given, for example. Because the classic situation as I encounter is you have a disclosure obligation to give teeth to allow somebody to police a freezing injunction. You have to be able to understand whether what has been produced is in compliance with the order or not. And if the court interprets the order and says yes or no, either yes, you've done what you were required to do, or no, you haven't, you need to do more. But that question of deciding what the order means and whether it has been complied with or breached is a different task than, as I understand it, the question of whether somebody should be proceeded against for contempt or punished for contempt. Now,
well, my lord,
that I understand is
some
your
part of
submission.
what my lord was saying seems to fly in the face of the citation from Mr. Justice Ip, which, as I understand it, was given approval by this court.
No, I think I am sort of trying to understand your submission, and I think it is that if the order is ambiguous, somebody may be found to not have complied with it or to have breached it, because the court will always say, what does it mean? Ultimately, the court can decide that. But that doesn't mean that you can proceed with a contempt application if, in fact, the order was truly ambiguous to start with.
That's right. That's my submission, and that's what I think Mr. Justice Ip was saying. Contempt of court is not established. Not established. There is no contempt. Contempt of court is not established if, on the proper construction of an ambiguous order, it is revealed the order has been breached.
And as my lord observes, the respondent appears to have conceded that in the agreed statement of principles.
Yes.
My lord,
Speaking entirely for myself, I have difficulty in squaring that as a matter of principle with the ingredients of a civil contempt. I mean, you're perfectly entitled to say both that that's what E.D. and Smith say, that's what appears to be said by Mr. Justice Ip,
well,
and that's what is conceded. I accept all that, but speaking for myself, I may need, at least for my own benefit, to look at some of those cases footnoted in Knowledge and E.D. because it does seem to me to be difficult to square as a matter of principle with the ingredients of a civil contempt, that since you don't need to intend to breach the order, you only need to intend to do the act, and the question is the act a breach of the order? It's difficult to see why then there shouldn't be a contempt if you do an act which, on a proper construction of the order, albeit ambiguous, is a breach of the order.
Well, I mean, unless and this is, like my lord, I'm going to have to go and read those things, because presumably, it might be said that those principles of what amounts to a contempt are predicated upon the assumption that the order is not ambiguous.
well, exactly.
But I mean, but the trouble is, this is quite an important.
Yes.
It's potentially quite an important
Area
issue that's lurking here.
And there's a rather different principle articulated in Abliazov number 10, which is that because contempt has penal sanctions, orders should be strictly construed.
Oh, absolutely.
And that one can understand. But if as a matter of strict construction, albeit that you thought it was ambiguous, it means X, as you can see, I'm having difficulty reconciling principle.
Well,
Perhaps without looking at the authorities, which we can take our own time to do, we can leave your submission where it is, which I understand.
Well, it's just 2 points. First, I don't know, with all respect to him, who Mr. Justice Ip is, or what I'm relying on is the fact that this passage, which seems to say in terms on the proper construction of an ambiguous court order, it is revealed the order has been breached, then there's no contempt. That's the appellate authority from Lord Justice Mummery in our submission. He is citing that with approval. That's the first point. The second point is it will not have escaped you in your reading of the Hadkinson case that in fact Mr. Hadkinson, who was in breach of an order, or in purported breach of an order, was sorting away money in an account in the name of his wife, which he claimed, or an account in his own name, I'm sorry, which he claimed was in fact beneficially owned by his wife. But he was not found to be in contempt for two reasons. One, that the order, which said nothing about beneficial ownership, but simply about assets, was ambiguous. But secondly, as a completely separate basis for acquitting him, was that to the extent which was assumed for the purpose of the argument in Hadkinson, that the account was beneficially owned by the wife, it wasn't an asset at all. And my lord...
Well, it wasn't his asset.
It wasn't, sorry.
It wasn't his asset.
It wasn't his asset.
Yeah, which was the wording of the order.
Yes, and my lord is quite right. Now that, of course, presents us with an irony in the present case, that if Mrs. Justice Cockerill's purposive construction of the order of Mr. Justice Waxman is correct, and if my clients have been clever enough to follow for themselves that reasoning and come to that conclusion, they must also have come to the conclusion that to the extent that these properties were beneficially owned by judges, that they weren't their assets. In other words, it wasn't caught by the order. It is fundamental to a contempt that there has been a breach of the order, and if these weren't assets in the hands of GHI, which would seem to follow from what was said in Hadkinson, then they weren't caught by the order at all.
Right, that's been very helpful discussion, if I may say so. I think we understand those submissions.
Well, my lords, I can't resist saying it. It's unfortunate, but a matter that evidently interests my lords and invites, in your view, further consideration, has to put up with me fumbling at the edges of the argument. But
you're being too modest.
I'm doing my best.
Especially as the point has been conceded.
Yeah. Lord, just on the question of ambiguity, can I take you, so that it doesn't get overlooked, to the freezing order of Mr. Justice Ter, which is in the supplementary bundle under tab 3. At page 9.
Yeah, thank you. Which paragraph?
And it's paragraph 7.
Thank you.
If the total value, free of charges or other securities, in brackets unencumbered value, of the respondent's assets exceeds 4 million, the respondent may remove, etc. This order, of course, postdates the original asset disclosure order, and there's no contempt alleged in respect of this order, but you see the difference in language, which is an indication that if the court is minded to take into account net values, if that's what they're after, rather than leaving it to the judgment creditor to sort out that position for himself, then it's very easy for them to say so. My Lord, I make the same point without taking you to it. The order of Mrs. Justice Mulder in the supplementary bundle under tab 4 at page 17, and the same wording is used. And in that context, I would like you to look at a case which is much relied on by the respondents, which is called Aspinall and Lim, quite a well-known case by a Mr. Lim, who used to gamble at Aspinall's casino and lost money and owed Aspinall large sums, which they eventually tried to secure payment of by various court orders. And the point I want to make...
Sorry, where is that?
that is in the authorities bundle under tab 11.
Thank you.
The first authorities bundle.
Yes. Where do you want us to go?
But I'd like to first, swiftly, just to look at page 248, which is the commencement
Yes.
of it. And you'll see in the first paragraph, 1.1, I just want to get the various orders that were made sorted out. An application by Aspinall's Club, an order for committal of the defendant for contempt of court, of an order dated September 2019, which is called the Andrew Baker order, and then a subsequent order quite soon after. It says 20th November 2018, but that must be a typo for 2019, as we will see, by Mr. John Turner, sitting as a deputy. And then if you go down to 6, to distinguish between the two orders, the Andrew Baker order was obtained without notice, making a freezing injunction prohibiting Mr. Lim from removing assets. Andrew Baker order also asked him to provide information. And then at paragraph 7, or paragraph 8, the consent order provided for the Andrew Baker order to be discharged, relisted in front of Mr. Turner as a deputy, who made the Turner order. The Turner order continues the substantive provisions of the Andrew Baker order. That was the point I'm rather laboriously making, that the Turner order, which is the one we're going to see what happened about, effectively reproduced the substantive provisions of the Andrew Baker order. And then if we can go forward to paragraph 56 on page 260, paragraph 56, picking it up halfway through that paragraph, value in this context must mean the realisable value, the purpose of disclosing which is to ensure there are sufficient assets to cover a judgment. The claimant cannot properly assess the information disclosed regarding these assets without understanding the extent to which they're encumbered by mortgage or other relevant encumbrance. This is a case that was cited to Mrs. Justice Cockerill, and which she relied on in coming to the construction conclusion that she did. And then this is the passage I draw your attention to. This is clear, in my view, from the text of the orders, especially paragraph 6.1 of the Turner order, which you recall effectively rehearses the earlier Andrew Baker order, which provides that the defendant can remove assets from England and Wales or otherwise dispose or deal with them as long as the unencumbered value of the assets exceeds 2.5 million. And the simple point I'm making is that just as with Mr. Justice Ter and Mrs. Justice Mulder, Lim was a case where it was made explicit that the encumbrances had to be referred to, and the extent to which my learned friend relies on this case, saying, "Oh, well, that shows what the obligations of a prospective contemnor are in this situation." I say no, that was different, and because it was spelt out in that case.
Right.
I mean, the point is presumably that if you have to construe the order as a whole,
Yes.
and if, as is commonly the case, the disclosure order is made in the context or as an adjunct to a freezing injunction, which contains the sort of ability to deal with assets if their unencumbered value exceeds a certain amount, then you might reach one conclusion in construing value in that sort of document. But not if it's a freestanding disclosure order.
My Lord articulates, if I may say so very neatly, a submission that Mr. Hilton made below to just that effect. Unlike Lim and other cases, the asset disclosure order was made before the freezing orders, and it was freestanding and said nothing about encumbrances. But the context was lacking. So overall, my submission is that if a reference to encumbrances is not made clear, a defendant could reasonably suppose, he might be wrong, but he could reasonably suppose that what he's been asked for is the market value of the assets, and it's for precisely that reason that the subsequent freezing orders by Mr. Justice Steer and Mrs. Justice Mulder did make that explicit, and why the same was done in the Aspinall and Lim case. So if I can move from there to the, and I may say that Mr. Boutguery was sent to prison for a year as a result of not initially mentioning encumbrances, and when encumbrances came to be mentioned, incomplete.
He's been sentenced
Yeah.
to prison. Is he actually in prison?
No, he's in Morocco. He's outside the jurisdiction. But that is obviously it doesn't affect the principles that we're discussing.
No, I understand that. No, it's just that when you said that he's been sent to prison, that's the only word. I was only querying the word that he's been sent.
Well, I'm sorry if I.
He was sentenced to prison.
Sentenced, yes.
Yes.
Yes. I'm sorry if I, in my enthusiasm, got carried away. So if we can move to contempt 4.
Thank you.
Dealing with assets while failing to maintain assets of $4 million in this in Morocco.
Yeah.
There's no dispute that, and it never has been, that GHI has been trading. That's they've never said otherwise, and indeed it's obvious from the disclosure of bank statements that money's going in and out in a way that's only consistent with continuing to trade. Mrs. Justice Cockerill based her finding on about an insufficiency of assets on the disclosure that was made of properties which turned out to be, for the most part, heavily encumbered. Although there's no agreement as to the exact extent of GHI's residual beneficial interest, and also bank accounts that were overdrawn, and said that the contrary picture, let's say a picture of substantial assets, well, said to be well in excess of 4 million, was based on a broad assertion by Mr. Boutguery. She didn't take on board that what Mr. Boutguery said about his assets being well in excess of 4 million, the company's assets being well in excess of 4 million, was confirmed by evidence from ADM itself in the form of Katie Pritchard's first affidavit, and in any event, by saying that the case rested on broad assertions. Mrs. Justice Cockerill appears to have been putting the onus of proving that the assets did exceed $4 million, and so there'd been no contempt, on the contempt law rather than on the person alleging the contempt, which is where, of course, it lies. We make the submission, which I made right at the outset, that it is inconceivable that ADM had not sought information of the same kind as they sought at the outset from the balance sheets of GHI, and that they must have been aware that, at least on the face of it, the assets were vastly in excess of the 4 million, and that the only way in which they could make the case that the assets did not exceed 4 million was to say, well, this is what you said when you gave your disclosure. In other words, we would say, putting the case on the basis of what was known to be a fiction.
Can I just see how this, the reference to Mrs. Justice Cockerill saying that the case rested on, GHI's case rested on broad assertions, we get at 91.
Yes.
And that is in the context of the argument which is identified at paragraph 90, which was Mr. Hilton's submission, based in the absence of any evidence in Mr. Boutguery's 6th affidavit at that stage. Which was not, well, they've got vast sums by way of trading, as shown by the evidence, but you can't be sure that they don't have more than 4 million, because we're only obliged to disclose assets up to 75,000, and there may be numerous assets.
No, many a mickle makes a muckle, as they say in Scotland.
And that they might all add up to more than 4 million.
Yeah.
And it was that which she described as an ambitious submission,
yes.
In the context of Roman II, broad assertions of assets well in excess of 4 million. Now, the findings in relation to this were not, did not take account, I think, of anything you now rely on in Mr. Boutguery's 6th affidavit, as to there being sums measured in hundreds of millions.
Lord, I took the reference to the broad assertions, not as to what Mr. Hilton's was arguing, but rather to Mr. Boutguery's, I think it's his 2nd affidavit, where he says, and by the way, our assets greatly exceed 4 million, and he didn't making no secret of that. Yes, so 2nd of April 2021, supplementary bundle, tab 12, page 60.
That's his 3rd.
Yes, it's at the end of paragraph 23. Copragri, which was the former name of GHI, has not taken any steps to hide or dissipate its assets or put them beyond the reach of any genuine or legitimate claim. It should be noted that Copragri...
I'm so sorry, it's my fault. Which paragraph?
Paragraph 23 at the end.
Thank you.
On page 60. It should be noted that Copragri's assets far exceed the value of the award and the amount that ADM has sought to freeze pursuant to WFO. And as I was saying at the outset, there's no secret, there couldn't be any secret about the fact that GHI is a very substantial trading concern with assets commensurate with that. And GHI knew that ADM knew all about that, because Katie Pritchard had spelt it out in her first affidavit. I had taken, I don't know, but I had taken Mrs. Justice Cockerill's reference to a broad assertion to that passage, rather than to the many a mickle makes a muckle argument, which I can see why that didn't prosper, and there's no argument about that.
Thank you.
So our first submission is that Mrs. Justice Cockerill was effectively reversing the burden of proof. She should have asked herself, well, what is the evidence about this? And the answer is the only evidence that there was, after she ruled inadmissible some valuation evidence that ADM had relied on, the only evidence there was that from Katie Pritchard, which indicated assets of somewhere around about $250 million.
Well, that's not quite true. There was Mr. Boutguery's own evidence. There were no assets.
Yes, that's right. I take that on board.
Yep. So it's not. I can't quite describe the other evidence as the only evidence.
No, but where that evidence was patently wrong, there's no way around that. Then she was entitled to say, well, what else is there?
So the evidence was this, was it? It was what Ms. Pritchard had said about the accounts to, I think, December 2017.
Yeah.
It was what Mr. Boutguery had said in his third affidavit, as you've just shown us, that they had assets greatly exceeding that, and it was what he'd said in his other affidavits in relation to the detail, which was no assets, at least up to the 75,000. Is that a fair summary of what?
Well, I would just add to that there's the inference that having accessed the publicly available balance sheets at the onset of the piece in 2019, an important part of what I'm saying is that it's inconceivable that, as an inference, it's inconceivable that the respondents didn't thereafter, on a regular basis, revisit the annual accounts to see what the position was. It would be a very obvious thing to do. And the fact that no word was said about that, Mrs. Justice Cockerill could draw the inference that the position had not really changed since Katie Pritchard's first affidavit. I appreciate that was out of date, but you would, if that picture had changed, then one would certainly expect the party upon whom the onus lay, which was the respondents, to adduce evidence about it. So once you've, as you know, the contempt law is entitled to be tried, to use the criminal expression, on the indictment. And just as in a criminal case, a man who's accused of murder in London is perfectly entitled to say, I've got an alibi, I didn't murder the man in London. At the time, I was busy murdering someone in Edinburgh. There's no merit in it, but you're not looking for merit, you're looking to see whether the charge is made out. And in our submission, it was obvious that GHI had very substantial assets, and that the idea that they should be judged on the basis of an interpretation of the order which only obliged them to disclose bank statements and real property assets was plainly a fiction. And that brings me to my second submission, is that this slightly smacks of the court being invited, and perhaps without saying so, acceding to the invitation to effectively punish GHI for a contempt for which they had not been indicted, which is to say, failure to disclose the obvious extent of their assets by the back door, by saying, well, we'll get you this way, we'll hold you to your initial affidavits in which you said this is the full extent of your assets. And although we know that's not true, but the assertion that it's not true involves your admission that you're in contempt of court, wholesale non-disclosure of the balance sheet assets, and so we're going to punish you in that way. I'm not suggesting that was articulated, certainly not articulated in the judgment, and not necessarily articulated in Mrs. Justice Cockerill's internal reasoning, which led her to her conclusions. But that was, in effect, what the way in which ADM were advancing their case.
I mean, can I just ask you about, I mean, you say that it, in a sense, should have been obvious to anybody that from Ms. Pritchard's witness statement, affidavit, sorry, that, well, it was then Copragri, had very substantial net assets. But, I mean, those figures were out of date. There were no up-to-date figures.
Well, my lord, that brings me to the inference, which I say is inevitable, that although there's no evidence about it, that having looked at the balance sheets at the outset in order to get the asset disclosure order, it's really not, it beggars belief to suggest that ADM didn't thereafter revisit the balance sheets on an annual basis.
But why does the judge, as it were, have to extrapolate from historic figures to an assumption which is different from the actual evidence that your client produced?
Well, my lord, because she has to be sure, she has to be certain sure that
On the evidence.
on the evidence. That,
I mean, it's sure on the evidence, not sure
yes,
as a matter of speculation that something might be that hadn't been put in
when
front
you
of
say on the evidence, the judge not only is entitled but is obliged to evaluate the worth of the evidence, and it was pretty plain that the initial affidavits of Mr. Boutguery making no attempt to spell out. I mean, where were all the cargoes? Where were his investments? How did they trade if they only had overdraft? I mean, it just didn't make sense. And so when you say the evidence, I mean, look, you've got to put in a dose of common sense and a dose of scepticism about what you're looking at.
Well, the common sense that your client didn't exhibit when he failed to produce the up-to-date.
Lord, I'm not.
Figures.
That's for another day and another indictment, and the reasons why he did what he did.
No, but the judge has to form a view as to what the unencumbered assets, as defined in the order of the company, were.
Well, the unencumbered assets, and that only relates to real property. And
Well, no, I mean, I thought the whole point about this debate was, the question was, did the proviso in paragraph 7.2 of the freezing order apply?
yeah,
Because if it did, then the freezing order wasn't breached.
yeah,
And if it didn't, it was.
yeah.
And in deciding the position, on the one hand, the judge has historic figures from audited accounts. On the other hand, the judge has your client's up-to-date compliance, so it's said, with the terms of the disclosure order. Why is the judge obliged to disregard what's actually put in front of her by your client in favour of some assumption as to what might be the current and up-to-date position of the company as disclosed by audited accounts, which your client hasn't put in front of her?
Well, if it was right that the full extent of that she could be sure that the full extent of GHI's assets was as disclosed by Mr. Boutguery, that involved the dissipation, the disappearance of assets of $250 million. And if as it was plainly the case, ADM had access to the balance sheets, if there had been the dissipation of $250 million, then no doubt we would have heard about it. In fact, we hadn't. It's a strong indication that the picture was broadly at least the same. And all you have to do in order to come to the conclusion that the assets are much as they were was to reach the view that Mr. Boutguery's initial affidavits, which were at odds with him, what he subsequently said, that the assets greatly exceeded $4 million, were wrong. And that sort of...
But it doesn't appear from her judgment that point was argued in front of her.
Well, I just confer with Mr. Hilton. Yeah. Mr. Hilton is showing me the transcript. Perhaps I could just read it.
Is this the one we've got at tab 21 of our supplementary bundle?
Yes.
Thanks. If you give us the internal number, we'll find it.
Yeah.
Page 224 of the supplementary bundle.
Supplementary bundle, page 224.
224, thank you.
E to D, I think there are other.
It's tab 20 minus 2.
This is the one that Mr. Hilton has found, but it says there may be others. It omits the fact the burden is on them and there's a right to remain silent there was no order that we had to disclose other assets that fell below the threshold. And so again, it would be unsafe on that basis to make the leap of logic and draw an inference on what is only a partial picture. That's the many a mickle makes a muckle. But then the point, coupled with that, is the fact that there is evidence from Mr. Boutguery at page B17, as we see in his April 2021 affidavit, the one we were just looking at paragraph 23 in the last sentence. It should be noted that Copragri's assets far exceed the value of the award and the amount ADM has sought to freeze pursuant to the worldwide freezing order. So there is evidence, positive evidence, confirming that Copragri's assets are in excess of 4 million. And there was apparently some reference to some other evidence as well.
Now that appears to be, as you said earlier, what the judge had in mind when she referred to broad assertion.
Yes.
But in developing your submissions today, you've been emphasising that that was not the only evidence, and that there was powerful evidence from the other side, and Katie Pritchard's affidavit. Was that point made?
Well, I don't believe it was.
Right.
Yes, Mr. Hilton is reminding me that he did make the point that it was part of the respondent's case that both Mr. Boutguery personally and indeed GHI were pretty wealthy outfits, and indeed it appeared, I think I gave the references in our skeleton argument, although we didn't exhibit those. So again, practice is discouraged by this court of exhibiting skeleton arguments from previous hearings, that they were described as I think the leading grain merchant or something, completely inconsistent.
Can I put another point to you?
Yes.
That what we're concerned with for this breach is using or dealing with or disposing of assets in excess of $4 million.
Yeah.
Whilst it was being suggested that there was real property that was sitting there that was worth $4 million, then that wouldn't have imposed any prohibition on trading with or dealing with any other assets.
Yeah.
Once, as the judge found, there was virtually no equity in those properties, it's not sufficient, is it, for you to suggest, well, there was much more than $4 million worth of assets which were held. There would still be a breach of the worldwide freezing order unless at least 4 million of those were not being dealt with, disposed of. Is that right? As a matter of construction of the order?
Well, I'm not sure I'm completely following. If I can just remind you from Katie Pritchard's affidavit that, for example, that there was evidence that GHI had equity investments worth, I think, $180 million, and indeed that similar figures are shown in the accounts that the balance sheets that were subsequently exhibited at the Senate hearing. So the point that I would make, I'm not sure if it deals with the point my Lord Justice Popplewell was putting to me, that there were plenty assets available on the basis of Katie Pritchard's affidavit.
But you still, but if they'd been dealing with, suppose those assets still existed,
Yeah.
and they'd been dealing with them, that would be a breach of the order.
Well, not if there was 180 million of them. As long as they kept 4 million safe.
What, so long as they kept 4 million saved?
Yeah. And if they dissipated $180 million worth of equities, then my submission is that someone would have heard about it. And it was reasonable to infer that hadn't happened.
Well,
I mean, it would be an extraordinary...
not all companies have the same investments in
No.
2019 or 2021 that they had in 2017.
No, but as I say, here, if there had been a diminution in those assets, if they'd been, someone had taken them or if they'd been sold, then if you accept the proposition that ADM must have been looking at balance sheets over the years, and they've seen that and told us, but they didn't.
But I think we understand your submissions
Yes.
on that.
Well, my Lord is encouraging me to move on. Can I move to contempt 5,
Yes.
which relates to Mr. Boutguery's personal liability for the contempts of GHI. The particulars of that are alleged in the core bundle under tab 8, page 111. I would just invite you to refresh your memory about what they say. Third defendant, sorry, that's the third defendant. It starts on 110. Second defendant is liable to be punished in his capacity as director or other officer because in relation to each of the first defendant's contempts, he knew of the relevant order and he either aided and abetted the first defendant's breaches of the court's order or willfully failed to take reasonable steps to ensure obedience to the terms of the order. I want to look at, in a moment, at the genesis of the language used there, and why, as we understand it, the respondents have chosen to found their case on aiding and abetting and willfully failing. But it just mentioned at this stage that both those expressions, aiding and abetting and willfully failing, are the kind of language which is usually associated with an allegation of criminal conduct. Aiding and abetting is not a creature known, I don't believe, would submit to English law. It's a creature of criminal law, which makes someone an accessory to the principle to a crime, and also willfully failing appears to suggest a deliberate attempt to flout or evade the effect of a court order.
It may not matter. I'm not sure that that general proposition would be right.
About aiding and abetting?
Yeah, because you can, I've certainly come across contexts like employment law where you can get civil liability for aiding and abetting, but it probably doesn't matter to your fundamental submission.
No, I mean, aiding and abetting in other contexts usually implies that the person who's aiding and abetting has done something himself which is criminally wrong or tortiously, perhaps tortiously wrong, but it does seem to involve some personal...
Well, that's, I think, your fundamental point, isn't it?
As opposed to vicariously wrong. I want to come back to those words and where they come from, because the nub of this argument is about whether there is some freestanding principle that makes directors liable, nothing to do with procedural rules, but there's some freestanding principle.
Nothing to do with?
To do with the liability of the director for his company's contempts. Is that a piece of freestanding jurisprudence, or does it derive solely from what I would call procedural rules?
Right.
That's at the nub of the argument. And I'm suggesting that words like aiding and abetting and willfully failing seem to refer to some kind of hybrid, on the face of it, seem to refer to some kind of hybrid contempt, somewhere between a civil contempt
Well,
and
you say that the judge thought that what was being dealt with was civil contempt.
Yeah.
ADM say that is what they're asserting.
Yeah.
ADM say there is a special rule for directors in civil contempt, and you say there isn't.
I say it's a procedural
It's a procedural rule which has gone with the 2020 revision, and that,
Exactly.
So we don't really need to spend very long on the wording of this, do we?
No, well, that's you've taken my first submission out of my mouth, which is uncontroversial, that Mrs. Justice Cockerill approached the case on the basis of a civil contempt. In other words, knew of the order, knew of the facts which constitute a breach of the order, but not necessarily knew that what was happening was a breach of the order. In other words, it's not in any sense a strict liability matter. Second submission, there is an important distinction between civil and criminal contempts. And I take you to the quote from the Spycatcher case, Attorney General against Times newspapers, which is in our schedule, tab 1, page 3, authorities bundle. I would just like to look and see what that authority, although it's not controversial, as to what that authority said.
Sorry, which tab?
It's tab 1, which is our schedule of agreed propositions.
Thank you.
So it's at the bottom of page 3, Attorney General against Times newspapers back in 1992, per Lord Oliver. The concession or the agreement is the respondent doesn't dispute that criminal contempt applies to all third parties, irrespective of whether they're directors or not. In other words, if you're looking at a crime, the position of directors is no different from anyone else. What Lord Oliver said was, where the prohibited act is not done by a party bound himself, but by a third party, a stranger to the litigation, that person may also be liable for contempt. There is, however, a central distinction that his liability is for criminal contempt and arises not because the contender is himself affected by the prohibition, but because his act constitutes a willful interference. So there's that word willful, which is used in the particulars currently alleged against Mr. Boutguery, with the administration of justice by the order in the proceedings for which the order was made. Here the liability is not strict in the sense referred to, but has to be shown not only knowledge of the order, but an intention to interfere or impede the administration of justice. So that very clear distinction. This is Justice Cockerill didn't consider criminal contempt or willful interference or anything of that sort, but she didn't think she had to, and she wasn't asked.
It may not matter, but it does seem to me that the words in 5 are not taken from there. They're taken from Tuvalu, which is concerned with civil contempt.
I'm sorry,
which is willfully fails to take steps.
Yes, it's from Tuvalu. Yes,
from Tuvalu.
Yeah, we're going to
rather
come
from Times newspapers.
Yeah, nothing in Tuvalu about aiding and abetting.
No.
But there is something about willful. I was simply saying that the word willful, one wonders how it got into Lord Wolfe's exposition, where he was taking it from, because willful usually implies you're doing something on purpose. And in Tuvalu, of course, it was, as you say, a civil matter. But,
that is what willful here means. It's an intentional act. I think everybody accepts that if you do an accidental act, then that's not a civil contempt. So you have to be a director aware of the undertaking, which puts you under a duty to take reasonable steps to ensure that the order is obeyed. And then if you willfully, i.e. intentionally, fail to take those steps, not accidentally, but willfully, then that's the civil contempt.
Yeah.
In accordance with the Tuvalu text.
Lord Justice Wolfe actually said what he meant by willful, which is slightly different. He said you've got to show that the director had responsibility for the matter and wasn't somebody else's responsibility. Which is perhaps slightly. But I'd like to have a look at Tuvalu in just a moment. Sorry. Thirdly, there's no general principle that directors of companies are responsible for companies' wrongdoing. Of course, a director can be guilty of a crime or wrongdoing by his company, but not on the basis simply of his office as director, a kind of vicarious responsibility, but only upon proof that he's personally involved. Obviously, if there's theft by the company and the director had his hand in the till, then he's liable, of course, alongside the company. But without that personal involvement, there's no general principle that if a company does something wrong, that directors are liable. That stems, the absence of any such principle. It derives from 19th century, the development of 19th century company law, culminating in the decision in famous decision in Solomon and Solomon in 1897. It's a corollary of that, that directors are not answerable for the sins of the companies. And secondly, the innumerable statutes that have been passed since in the 20th century and in the current century imposing criminal liability on directors in special circumstances. I cite I think a page in our skeleton at page 40, paragraph 103. I won't take you to it, but I recite the numerous statutes, the Theft Act, Bribery Act, Health and Safety at Work Act, which specifically say that directors will be criminally liable alongside the company. And that, of course, wouldn't be necessary if there was any general principle. So I support my third submission by reference to Sullivan and to those statutes. Fourth submission, until its repeal, CPR 81(4) brackets 3 provided a procedure, and I emphasise procedure, for enforcing court orders against companies by a committal order against the directors. Neither CPR 81, which came in 2012, or its predecessors, which are the rules of the Supreme Court, Rule 45(5), and then going back behind that, the Common Law Procedure Act of 1860, I think, Section 33, none of them created a new species of contempt. What is plain from the wording of all those rules is that they were providing a procedure for enforcing judgments against companies. They weren't creating a species of contempt by directors. They were creating a procedure for enforcing judgments against orders or judgments against companies. My Lords, that is stated in terms by the former CPR 81, which I'd like to take you to at the second authorities bundle, at tab 3. Page 24. It's actually page 25. This is an appendix to the statutory instrument. And it sets out the former CPR 81, and you'll see at 81.1, this part sets out the procedure in respect of contempt of court, and then saving for other powers, this part is concerned only with procedure and does not itself confer upon the court the power to make an order for committal or sequestration. And those are, in my submission, important words, that there was no, on the face of it, these rules specifically eschewed any pretense at making substantive law. It's all about the procedure for enforcing orders for committal and, so far as relevant, for sequestration. And then one sees at the material part of the rules on page 26, 81.4, if a person required by a judgment or order to do an act doesn't do it by the time fixed, etc., then 3, then subject to the Debtors Act, the judgment order may be enforced by an order for committal. So it's all about how you enforce the orders, and it's permissive, may be enforced by an order for committal. And then at brackets 3, if the person referred to in paragraph 1 is a company or other corporation, the committal order may be made, again permissive, against any director or other officer of that company or corporation. And I essentially make, I think I've already made the submission, and make the submission now, that this is the only basis upon which, at any rate prior to the repeal of 81, orders could be made enforcing orders against companies, against their directors. This is where that power comes from, and there is nothing else, and there is no guidance given within the rules about how that shall be exercised, which is why in cases like Tuvalu, the Court of Appeal gave some guidance, but not in our submission, doing more than explaining how a procedural order should be enforced, rather than creating any substantive law.
So you're saying Tuvalu doesn't concern any rule of substantive law?
Yes, and that's the next thing I want to look at.
Just before you leave this, can I just understand how you say this works? 81.2 says that this part doesn't itself confer upon the court the power to make an order for committal.
Yes.
So if there was, at the time this was in force, a power to make an order for committal against an officer of the company, that can't have been a power which is to be found in 81.43. Where was the power?
Well, you wouldn't need 8143 if there was a pre-existing power. And the fact is, I mean, it's probably semantics, and I think this is something that the White Book has agonised over a little bit as to really what they mean when they say we're not creating a power, because that's really what they've done. And because there wasn't, apart from the procedural rules, there was no power. There is no principal power.
So although 81.2 purports to say that 81.43 is not creating a power, you say that is what it does.
Well, if it doesn't, then the power doesn't exist, and there's no dispute. I think that power did exist.
Yes, but what I'm putting to you is that this version of the rules at least purported to proceed on the basis that the power was not contained in 81.43 itself, but did exist independently. Just if one reads the rules, that's simply what this wording suggests. Is that right?
Well, not really, because if you then look at 81.4 brackets 3, there would be no need for that if there was that is what creates the power. I don't think there can be any arguments about that. I mean, the only issue is why the draftsman thought fit to say that 8143 wasn't creating a power. I mean, if it wasn't, why have it?
Well, as I understood it, there is some suggestion in some of the materials I've read that if a company is ordered to do something and doesn't do it deliberately, then the company may be in contempt. If a third person, as it were, has brought that about by encouraging the company not to do it, that third person can, as a matter of common law, as I understand it, be proceeded against.
As a criminal contempt.
As a criminal contempt. But that's not mentioned here, that possibility.
This is civil contempt.
But as I understood it, there is some suggestion that because directors needed a bit of a reminder of their obligations in relation to companies. Yeah, that the suggestion was made that because this is quite an old provision, it's been around for a while, was that directors it was felt necessary to, as it would give directors a bit of a nudge to remind them that they actually needed to do something if a court ordered their company to do something, and that if they didn't,
well, that I think that's the genesis or the background to our rules of the Supreme Court 45.5, which is the immediate predecessor of this. But it all comes.
But if that were right, I mean, to answer the question you posed a moment ago when you said, well, it's not clear what it's doing there, if it's not conferring a power. I thought one argument is that it doesn't actually change the substantive law, but it does provide a reminder to directors of what the consequences of failing to ensure
And I
compliance
think
by
that
their company.
observation was probably originally made in connection with RSC 45.5, which is very similar
Yep.
to this provision. But my point is, I'm not sure I'm necessarily wholly got my Lord's point, it's my fault, but they're both procedural. And I was saying about if my Lord Justice Popplewell was right, that there was a pre-existing, freestanding power, then you wouldn't need either the provisions of the rules of the Supreme Court or indeed of this CPR.
Yes, but you phrased your point in terms of if there wouldn't be a need.
Yeah.
Well, one alternative, as I understood it, one alternative way of looking at it is there is a freestanding ability. There's not a need to have it, but it's desirable that it should be there, conceptually, to make it clear to particularly directors, who are the people most likely to be responsible for a breach by the company.
Well, that may be the rationale. I'd understood
I don't know.
that was the rationale for the rule. But my Lord, I'm not following where this freestanding substantive power has come from, if not from a succession of relevant rules. And there's no jurisprudence, there's no principle that one can look to as to why that should be, and nor, as far as I know, in any case that says that this has been the law. It's absolutely clear in our submission. There's two ways in which you can make a director liable. One is if he aids and abets, in other words, gets criminally involved in a contempt, which has got nothing to do with the aiding and abetting words, not in Tuvalu, no, really criminal contempt, or civil contempt by reference to the rule. And that's all there is. There is substantive law, obviously, about directors being responsible for crimes. It's always been, just like anybody else, who willfully subverts the effect of order. So,
sorry, I don't want to slow you down too much, but can I just clear my mind on one thing? You said, well, if there was a power pre-existing which was not created by 81.43, what would be the point of putting it here? Can I just see what your answer is to a suggestion that might be made, which is, well, you need to spell it out here, because the way this is drafted is in 81.4, it makes a reference to being able to enforce an order for committal where there is disobedience to a judgment or order. But if you had 84.1 on its own, it might be thought, well, that looks as though there's only a procedure for making a committal order against the party against whom the order is made, so that 81.43 is included to make clear that the rule of law, that if there be such, that pre-exists as to directors being liable, can be given effect to.
Lord,
Is that a tenable reading?
Lord, with respect, I know of no jurisprudential basis or principle that would make a director liable for a civil contempt. Plenty of law about criminal contempt, but not for a civil contempt, and nor do I find anything in the rules apart from 81.43. That's where it comes from.
All right, thank you.
And just while we've got this open, in the authorities bundle, if we can go to 81.20, which is on page 32, which is an almost mirror image provision in relation to sequestration.
Sorry, can you give me the page? I've lost
It's page 32 and it's 81.20.
Yep.
Sometimes referred to in the white book as 81x20 to indicate that we're still with the old CPR 81. A person required by judgment to do an act doesn't do it or disobeys, subject to the provisions of these rules, and if the court permits, may be enforced by writ of sequestration. And then 3, which really mirrors 81.43 that we were looking at, if the person referred to is a company, the writ of sequestration may be in addition, be issued against the property of any director or other officer of that company or corporation. And before we leave that, I'd just say that, as you know, and as I think is pointed out in the agreed note on the various statutory instruments, that provision, and indeed the whole of Old 81, was specifically preserved in relation to sequestration, a step to preserve, if you like, 8120, which is conspicuous by its absence in relation to the equivalent position so far as contempt is concerned. I draw your attention to that. One talks about the intention of the draftsman, and I think it's important in considering that to draw a distinction between subjective intention, what did they think they were setting out to do, or what were they trying to do, and the objective intention, which is derived from the words used. And a lot of the points that are made, will be made, I think, by my learned friend, and are made in the White Book about the inference that the draftsman obviously thought that 8143 was being preserved. That may have been their belief. It may have been their intention that that's what would happen. But that's what they subjectively thought when they were sitting around the table doing the drafting. Is neither here nor there. The question is, what are the words?
Yes.
What do the words say? And
Well, it's not only about the words, but I understand your point. It's not about subjective intent.
No. So just be careful when we talk about what did they...
Yes. Now, Mr. Watson Brown, you've mentioned Tuvalu a number of times, but you haven't actually been shown it yet, and it seems rather important.
Yes, we'll come to Tuvalu. I think the context in which I want to look at Tuvalu is whether there is a freestanding principle about liability for directors, which has, as using the words that my learned friend team have used in the particulars of the relevant contempt, on the one hand, has there been a aiding and abetting, or has there been a willful action? That's the two things that he says. A willful failure to make sure the order is dealt with.
Yes.
And I want to show you the relevant passage in Tuvalu.
Yes.
Which tab 2
Yes.
of the authorities bundle at, I think, page 16.
Yes.
So if I can just pick it up on page 15, that letter G, under the rubric "the lack of evidence," the judge found that the case against the second defendant, that's the director, was established in two ways. And this, of course, was the company that took it upon themselves to print their own Tuvalu stamps to sell to stamp collectors. They were rogues, and there was a director who was involved. The use of copying and dealing with stamps, etc., and placed an order with format. So was directly involved. And then the second way, so we've got two different ways of putting the case. The second way was based on a breach by the second defendant, both of his personal undertaking and of the company's undertaking. Here the judge concluded, I am of the opinion that even if, contrary to my earlier finding, the director had not instigated or approved the policy, and he would not have given the undertaking in question or permitted such an undertaking without at the time of making sure that no prohibited stamps were on order. If he had done that, he would have been able to stop the printing. His failure to do so, in my judgment, amounted to a breach by him of his personal undertaking, and exposed him to liability under Order 45, Rule 5, for breach of a similar undertaking by the company. And Order 45, Rule 5, I would invite you to assume for present purposes pretty much the same as the order, the CPR we're looking at, creating the procedure for enforcing orders against companies, against directors. So the court considered the appeal in respect to the judge's finding of contempt on the basis that the second defendant had knowingly caused or permitted breaches of the order, that's the person involved. We've decided that the reasoning of the judge was guilty of contempt cannot stand. Having come to this conclusion, the second ground upon which the second defendant was found guilty becomes of considerable importance. So now we're looking at the rule, the procedural rule that makes directors liable for company contempt. This is the crucial passage. In our view, where a company is ordered not to do certain acts, and I do preface this by emphasising what he's talking about is the application of a rule, what we say is a procedural rule, not referring to some freestanding principle, but to, as he said earlier, to 45, Rule 5, now becomes of real importance. In our view, where a company is ordered not to do certain acts or gives an undertaking and the director of that company is aware of the order, is under a duty to take reasonable steps to ensure that the order or undertaking is obeyed, and if he willfully fails to take those steps, the order is breached, he can be punished for contempt, and then he defines willful. We use the word willful to distinguish the situation where a director can reasonably believe some other director or officer is taking those steps. And it's fundamental to my submission that Lord Justice Wolfe is here talking about what Order 45, Rule 5 provides. He's not referring, if you look at the history of the way this is introduced into his reasoning, he's not talking about, although it looks like it, a bit that's been sidelined by the respondents. It looks as if he's referring to some general principle, but what he's doing is telling you what the procedural rule means. And to the extent that he adds a little bit of Court of Appeal jurisprudence to what the rule says, it is confined in our submission to the word willful. And it's slightly unusual in our submission, slightly unusual use or meaning that you could use to willful to distinguish a situation where a director can reasonably believe some other director is taking those steps. So it's a question of differentiating between the man who is, let's use the word responsible, and the man who has got no responsibility in relation to the matter. But that is the only gloss that the court is putting upon the procedural rule, which, as I say, for practical purposes, can be taken to be pretty well equivalent to CPR 81.4.3. And there is nothing in Tuvalu about aiding and abetting. And it's our submission, maybe just a matter of impression, that the word willful has crept in and it's not really, when one sees the definition that Lord Justice Wolfe is giving to willful, it's not really a very happy use of that word. What he's really talking about is direct responsibility. Willful usually means, in our submission, and as it's often used in contempt in the criminal context, it means deliberately setting about to subvert the court's order, not just having responsibility, having responsibility for doing something, rather than B. And so,
well, I think willfully first came in the first version of the rules of the Supreme Court, in between the 1860 Act and what became Order 45, Rule 5.
well, my Lord's ahead of you there, yes.
And was then subsequently interpreted as meaning essentially intentional act, not willful breach of the order.
Yeah.
So maybe the word willfully was language that Justice Wolfe picked up from the precursor to Order 45,
well,
Rule
as
5.
I say, my Lord is ahead of me there. But when one talks of an intentional act, I mean, that you have to know that the order is there. You have to know the facts. But in a civil contempt, the acts that you're doing, which constitute a contempt, may have to be intentional. but they don't have to. The intent does not extend to a desire to.
No. No. So I'm sorry to slow you down, but I'd just like to get my mind clear on this. So under this rule, as you say, then procedural rule, directors were in a different position from any other third party in relation to civil contempt. Is this right? In two ways. Firstly, that they didn't have to have an intention to breach the order. They only had to have an intention to do the act. So the mens rea was different. It's the civil contempt mens rea.
Yeah.
And secondly, in terms of the actus reus, they could be guilty if they simply did nothing. Whereas for a criminal contempt, someone couldn't, or wouldn't usually anyway, be guilty of a criminal contempt simply by not taking any steps.
My lord might be able to assist me as to where the idea of doing nothing
willfully takes to fails to take the steps. So if essentially what Lord Justice Wolf seems to be saying is all directors are under a duty to take reasonable steps to ensure that an order against the court is obeyed, and if a director does nothing, then that is a breach. But I'm going to add the rider willfully because it's okay if he thinks somebody else is in charge of it. So that's the gloss you put on it as the responsible person. But one wouldn't normally think that a director, in the context of a criminal contempt, could be found guilty of a criminal contempt just for sitting on his hands and doing nothing.
Oh, well, my lord, I'm not sure how readily I would accept that. In the criminal context, if a director is aware that something needs to be done and that it falls to him to do it, and he deliberately and willfully, and with a view to subverting the effect of the order, decides not to execute it, you would be guilty of a criminal contempt.
I mean, isn't this all dealt with at page 18 of the authority?
Yes, if there's been a failure to supervise or investigate, or a willful blindness, his conduct can be regarded as willful. And Order 45, Rule 5.
I mean, at the top, there must be some culpable conduct on the part of the director before he's liable to an order of committal under Order 45, Rule 5. Mere inactivity is not sufficient.
Yes, he's differentiating, I think, between mere inactivity and willful. Willful inactivity.
In other words, if you deliberately do nothing, or close your eyes to the fact that nobody else is doing anything either.
That could constitute a criminal contempt, and also, according to this, and also a civil contempt.
Yes.
But my lord, perhaps the underlying point, and the point that I'm reluctant to be deflected from, is all of this is telling us what Order 45, Rule 5 means.
Yes.
And if it's procedural, well, what the court is helpfully doing is telling us how the procedure should be used.
Do you also make the submission that whatever its status was, it's now been repealed?
My lord, of course. Yes. It derived from a procedural rule which is no longer in existence. The procedural rule in relation to sequestration has been carefully preserved, but not in relation to contempt.
But is your submission that at common law, this court, indeed any court, has no inherent jurisdiction, as a matter of substantive law, to hold the director to be in contempt because the company is in contempt?
Yeah, that is my submission.
Even if the director falls within the sideline passage at page 16 of the authority?
But no, my lord, I accept that Cockerill was rightly decided, but it doesn't decide very much. All it decides is that Order 45, or effectively...
I understand that submission. So you're saying that leaving aside Order 45, leaving aside the now repealed CPR, if otherwise you fell into that description,
then you
in the middle of page 16, there is no substantive rule of law which says that.
Precisely.
I understand the submission.
And indeed, as I was at pains to point out, Lord Justice, the key passage from Lord Justice Wolfe that's been sidelined is predicated on, now I will explain how
I completely understand that point.
Lord, I'm turning the pages rapidly. May I just have a moment
Of course.
to see where we've got to? Yes, I'd like to look at sector guard briefly in connection with aiding and abetting. That is under tab 5 of our authorities bundle. And may I look?
Yes, before you do that, may I just inquire how long you're going to...
My Lord, I'm very nearly finished.
Right.
I said I would be the morning,
Yes, thank you.
and but I want to say something about sentencing,
Yes. Right, tab 5.
and indeed to look at Foxton's judgment.
Yes, which paragraph do you want us to look at?
Can we look please at paragraph 39?
Yes.
I must consider a separate submission, namely that the committal application discloses no reasonable grounds against the director personally. Submitted that for a director to be liable in contempt for his company's breach, the court order required either proof of aiding and abetting or proof of his willful failure to take reasonable steps to ensure the company obeyed the order in question. Liability for aiding and abetting is an ordinary aspect of the common law. My Lords, we will see, I think in a moment, that what he is there saying is that if you are guilty of a crime, the director is guilty of a crime by aiding and abetting a breach of the order, then of course he's liable. Then that is contrasted with liability based on willful failure to take reasonable steps. And under Order 45, Rule 5, that's the procedural rule, as interpreted by the Court of Appeal in Tuvalu, as follows. So he's saying there are basically two different ways you can approach this. You can approach it under the criminal law, what he calls the common law, which is aiding and abetting. And then differently, liability based on a willful failure to take reasonable steps is under the rule. He's not suggesting in sector guard that aiding and abetting is part of the way in which the procedural rule is to be interpreted. He's drawing a distinction between the common law and procedural rule.
Yes.
And we can see that, I think, at 42.
Yes.
On page 73, talking about the Bieber case, establishes debunks the principle that directors, whatever their role, can be liable for civil contempt. He says, no, they've got to be some involvement. In my judgment, the Bieber case establishes no such principle. The issue in that case was whether a breach of an undertaking gave rise to the same consequences under the rule as the breach of an order. I consider that the effect of the Tuvalu case is that an applicant for the committal of a company who relies upon a breach of an order or an undertaking must disclose in the committal application a case for the establishment of responsibility of that director either on the grounds of aiding and abetting or a willful failure to take reasonable steps to ensure that the order or undertaking is obeyed. And in our submission, he's there talking about the two different ways in which a director can be found liable, one for a crime, aiding and abetting, and the other for willful failure. Bearing in mind, there's nothing in Tuvalu about aiding and abetting. It's clearly a different beast. And there is a useful passage about, I think I may have already taken you to it, on paragraph 47.
Yes,
I've
we've seen
already,
that.
already dealt with. There's possibly one other passage. A moment. Lord, I was then going to turn to Mr. Justice Foxton's decision in Olympic Conservation.
Well, we are over 1 o'clock now.
Yes, well,
How much longer are you going to need?
Well, I'd try to deal with it in 15 minutes.
Well, in that case, we will resume at 2 o'clock, and I will hold you to 15 minutes. I will expect you to finish by 2:15.
Yeah.